Whenever you're ready. I have a sense of getting that good.
Good morning, here, and may I please declare, yes, I noticed that this event very.
All right.
So I found that this is going to be 2007. You are on a field forces in your house. Reversed because big praise and it says and modified lines that is undisputed and we correctly second thing that's on the screen is that no court could or intended did modify the terms. And that leads to two things. One, the courts were trying to act in accordance with inaction. And number two, that means that the right to word would. The bottom, we take in mind those unspeakable. We're on the view. And in fact, conflicts. Said that we don't want to have
and the Dodge procedure requires immediate appraisal by an appraiser selected by the manager in the state. And the whole reason that the divorce court went through these sort of machinations was because it determined that it was impossible to adequately accurately appraise the value of the units at that time, correct?
that is correct. And so the divorce court started with that premise as stated in the judgment.
There's no good way about it.
There's no good way about it. And so then the judgment, and this is first order, they very that direction was that it was going to divide equally in our next in common. And instead, John had to full immediately transfer units and to full make the wife the owner of them. And then it said, following the transfer, this is here, to the extent wife ever wants to divest herself of any of her units, then the husband will have the right for it. Yes.
If we were to trigger the enforcement order to require to immediately trigger the Dodge procedure, and thus immediately trigger not just an appraisal of the units, but a one-sided appraisal of the units, that would be completely inconsistent with everything that went into the formulation of the final judgment, correct? At least that's your position.
That is my position, and that is true. And let me clarify something here. The argument has never been that the enforcement order triggered the DOTS. The argument has always been the final judgment triggered the DOTS. So if you look at our motion for summary judgment, it's the final judgment. If you look at what the order on said, it's the final judgment triggered the DOTS. And then the argument is, well, that the enforcement order confirmed that. The enforcement order did exactly the opposite. The enforcement order found that John's use of the DOTS having an immediate appraiser, offering units to Alana, and then transferring them to him and saying, I'm sorry, Judge, I couldn't comply with your order, that was improper, that it was in violation of the final judgment, and it satisfied that transfer under the DOTS procedure. So it would make no sense to interpret the enforcement order somehow confirming that the judgment triggered the DOTS. That's the argument was made. That, to your point, which I think made a little bit better, because it at least like some of the language in enforcement orders. And the enforcement order trigger, if it's enforced in, and I don't think it can for a number of reasons. First, that really would make no sense. The enforcement, the judgment requires him to transfer. And then his act of not transferring when he could, all of a sudden, now he has to file enforcement, and now he gets the right to use the DOTS procedure, but the court didn't set it. So you really can't align their argument that the final judgment triggered or any argument with reading of the judgment, wording of the enforcement order itself, or the operating. And let's go to the operating. That's the argument that was operating. The operating agreement, if you accept it in the original, then the operating agreement says that we will have to settle this.
Was it your position that the original transfer is worded by the family court was under 9.1?
Yes. And that was precisely what was argued in. Right. In the enforcement proceedings, John came and he said, you can't transfer them. I want to come back and push back on one point that is not overtly said in the brief, but I think that they're arguing that and that is that PCP and John can sit silent while the judge ordered the implementer of units to make the owner and not object and say, okay.
And DCP had intervened, right?
PCP was a party to the divorce. They're representative of that. So the fact that they could just sit back, let the judge enter an order that they didn't think they could comply with the operating agreement, not raise that issue on appeal, and then say, aha, now the DOTS applies, they're prohibited by that. Because that order that required the transfer to make for owner, it didn't bring owner rights, they had to bring that.
Could you, following the argument you made, can you speak to the argument that Kelly's made in their brief that the former wife has made the contrary, has sought contrary relief in the past, that sought relief that would require PCP to purchase her shares? Could you explain?
Sure.
They're going to explain their own argument.
That's an equitable estoppel argument. Equitable estoppel to apply has to be two things. One
Well,
is.
could you just go back and explain the premises of their argument?
Okay,
The relief she sought, where she sought it, so we
Right.
put it in context.
right. So the relief, when you saw it, was a motion to enforcement in the family law. This was after PCP sent her a letter, and PCP said, we're exercising the rights that we were given under the DOTS. For your shares. Here's an appraisal, elected by John, almost exactly the same number that she was asked to accept before. And you have to accept that appraisal and take this value and transfer it back to shares. Ruby responded to that letter and she said, I have no obligation to sell you my shares. And if I were to sell them, that would need to be out here. And then she got a motion in the family court, and then I read that motion, a little bit of an explanation. She explained, I was awarded these shares years ago, they keep telling me they're not mine, that I have to buy them. And so I'm asking the board, you don't think I have an obligation, she referred to that, she wrote obligation, so the PCP should be purchased and based on
And they're using that to say now that she's a stop from arguing that she has the discretion to sell them.
right, so their argument is that argument that PCP had in mind with their price, which again said that she didn't have an obligation to sell. Something and equitably that stops her from taking the position that she does. So there's not a direct link there. And even if there were, in order for equitable involvement, like there has to be successful results. You have to have.
Rely.
She did not. That motion was dismissed. The one case that PCB cites is the case where a person started a position, the other person acquiesced, they were right, then they came around. PCB didn't acquiesce. PCB opposed that motion. And I think the judge, thankfully, you know, okay, that's a matter of working.
So another question. So I follow your argument going, you know, your last argument first, that would order that, you know, judging by the terms of the operating agreement itself, transfer from the John to Uni would not require Uni to sell because John is the transferor. But before we get to that, if you want to get to that, I'm sure they're gonna try to address it. What just it is the requirement. I kind of want to leave that aside, and there's this argument that there's this point that John gets a right of first refusal before PCP. Could you explain that? Is that inconsistent with DOTS? I mean, in other words, how can John have a right of first refusal if she sells if the DOTS is now that she's the owner? Your argument is she is now would be the transferor in a future transfer or sale if she were to choose to do so. And just maybe it's important, maybe it's not, but why would that override the DOTS? Why does he get the right of first refusal if she later chooses to transfer? Was that a requirement of the final dissolution? So, but that is that cross purposes with your other argument, which says that everyone agrees the operating agreement controls, but is that the final dissolution overriding the operating agreement by saying, yeah, that the DOTS would require Uni to give the right of first refusal to the PCP, but no, we're going to say John gets it.
I don't think it's necessarily inconsistent with the operating agreement because again, John is the manager. So under that provision, John can consent to any of those transfers. Even if John somehow became non.
So in other words, he can say, well, I'm waiving the DOTS.
He could say that if she offered him the right of first refusal, that would be consistent with being allowed to accept the transfer or approve a transfer as a manager.
But he could also, according to the final judgment, take it individually, as opposed to selling them back to PCP. In violation of the DOTS, which gives PCP the right. No, but 9.1 only regards transfers. Oh, so you're saying maybe I misread it or misremembered it. 9.1 can allow the manager to authorize a sale from another member to someone else.
Yeah.
Okay.
Right.
In other words, the sales governed by 9.1 are not only sales of shares held by the managing, owned by the manager,
Right.
but essentially a general ability by the managing member to sanction sales in derogation of the DOTS. Okay.
And so, and also, and the other point that I would have to back to the operating agreement, but the other point would be if PCP or John felt that right of first refusal was an infringement on their property rights, then the final judgment is the time to phrase that. The appeal is the time to phrase that. But let me talk to, because I don't think, this isn't disputed. It's not really addressing the answer to and that is how the DOTS provision actually works vis-a-vis 9.1. So 9.1 says that there can be a transfer with the written consent of the manager. And then 9.3.1, which is a provision that they allow, say that the judgment triggered, says provided any transfer permitted under section 9.1 of this agreement shall not be deemed an offer to sell under 9.3. So the two are mutually exclusive. So if you accept that the court was complying with the operating agreement when it ordered the transfer, that gave them the rights to own, then the only thing in the operating agreement that's consistent with 9.1, it doesn't trigger 9.3, that's cited in the enforcement proceedings. And then you have, now it will be operates like any other owner of the becomes well. So. The agreement. Judgment. The only way to do those all consistently. And in line with what the boards have ruled consistently, he owns the unit, does not have to sell unless they divest, unless something requires to do so.
You're at 15 minutes.
You know, the reality here is that 5 years ago, Tony was supposed to be made the owner of these shares, and concluded to a 40-year marriage, and it was the most significant asset. And 5 years later, the board of the board that did not continue to be boarded, that is on review, boards and upsets group that the property rights.
If you support, my name is Marie Borland, I'm here with my law firm, the Brighton County, together we represent the asset group. We're requesting today is the firm the trial for summary judgment order, because the issue before the trial was whether PCP was the right purpose to the households. Membership units and PCP under the USDF for the class in the underlying. So it seems like the issue before the court is very complicated in this argument, but I want to go back to what the input arguments are. The primary appellate argument was
Can I start with the last one, since you're proposing an order, and I'll propose a different one. The last argument made, which was about the construction of the operating unit itself. You seem to be saying what I don't think on my reading, the operating unit says that the DOTS 9.3.1, I believe, says if a member attempts to transfer his shares, then the transferee is deemed to have offered to transfer the shares that she just received from the transferor. But with the provisions, the word member refers to the member who is attempting to transfer his or her shares. And so the DOTS would the only way to possibly read it, leaving aside the argument that the transfer is made under 9.1. Let's say that the 9.3.1 was triggered by the dissolution, the final dissolution, right? Because it was an ordered sale, an ordered transfer, and a dissolution proceeding. That would have required the shares to be transferred to PCP before they even became Uni's property. Because the transfer, the ordered transfer, let's take your argument that 9.3.1 applied to the ordered transfer of John's shares to Uni, is deemed to have been an offer to PCP, a right of first refusal by PCP, so she never would have even gotten the shares. But that didn't happen, did it? No, she got the shares. So explain your construction of the operating unit.
USDF provision didn't say that this is child. Higher level. Why in the world is this provision not? Is that wrong?
Let me just, before you get into that, I just want to make sure I'm clear. What do you think triggered that provision? Final judgment? Because I think that's what the appellant.
So this, again, if I can explain the provision. So, and Judge Ronalino said, and it was the order that required John to transfer the PPP units to you. That was the triggering event.
That was the final judgment.
Well, the final judgment, yeah.
Final judgment required.
It really doesn't matter. It was either the final judgment or the enforcement order. But yes, the amended final judgment. And keep in mind that when the Judge Williams entered the amended final judgment, she said, I'm not making any money whatsoever regarding these obligations that are the PCP operating. So the divorce court never weighed in.
Well, that was the basis of the enforcement agreement. Was the final judgment was entered that required Mr. Haskell to immediately transfer to his former wife these units. He did not do it. Instead, he followed the 9.3 procedure and tried to transfer them that way. He filed the enforcement proceeding, and the trial court rejected that and said, no, final judgment requires you to transfer them to her. And I'm going to transfer them via this order, which you got to go record with the Secretary of State. And then Mr. Haskell appealed that, making the argument that the operating agreement was triggered, the 9.3 of the operating agreement was triggered by the final judgment, and that he appropriately invoked 9.3 rather than just directly transferring them to her. And we affirmed the trial court's decision, rejecting that argument.
Completely consistent with my point of view. So once again, if I may, why do these provisions even put in these types of agreements? And Judge Wanda, that again, voice of reason, when I'm saying this court is found, that and many of the agreements that I've seen provide include corporations some measure of protection for the various owners of the business that would happen in the occurrence of death or divorce. He said these are very common standard things. They're to keep a corporation, the members of a corporation from having to do business with the divorced spouse. So what the provision says is when there is a divorce decree and there is an attempted transfer, why does it say attempted transfer? Because there's going to be an immediate buyback. When in a divorce decree, a member is required to transfer shares, as happened here, to
Which member? Okay,
to the spouse. This is the triggering event, and this is the entire.
so John,
What was argued in the previous appeal and
No.
rejected?
It was correct. Actually, they should be stopped from making this argument because John and I on the advice of counsel said.
Right.
Thought that because it said attempted transfer, that he wasn't allowed to make the transfer pursuant to the divorce decree. He had to then invoke this provision and transfer them to the other. So.
okay, wait, so if you don't mind, so John said, oh, John was taking the construction that I, for the sake of the discussion, was presented to you, which is the way it reads, in my opinion, upon reading, and I'm very happy to be disabused of that if I'm incorrect. John, a member, is deemed to have made an offer to sell to PCP if that member, John, attempts pursuant to a court order to transfer. So that would be his argument, right? And Judge Kelly is pointing out that that was shot down by the trial court and this court. So now tell me then, if that's not what triggers the DOTS, what triggers the DOTS as to UNI? Who is UNI attempting to transfer the sheriff's stake?
He's not attempting to transfer the shares.
Okay, who is attempting to transfer? Who's attempting to transfer the sheriff? Okay, but
Attempt to transfer the shares.
so why doesn't that trigger the DOTS?
It- that's true.
So UNI should never have gotten the sheriff's to begin with.
It was going to be an immediate buyback. Transfer. So again, what I love about the why are these provisions in here? If this court were to accept Uni's argument, we may as well just write out that whole DOTS provision from the agreement.
But that is not what they did by saying they're calling us. Whereby if they could take it.
Okay.
Limited transfers. John is doing my transfer. So once again, Mr. Monday, the divorce lawyer, Uni's divorce lawyer admitted on the record of the divorce.
Then why would 9.3.1 talk about transfers permitted under 9.1? And anything under 9.1 is prohibited.
Because whatever happens under 9.1 is not authorized, whereas here there's an authorized divorce decree. But again, I would ask this.
Wait, where does 9.1 authorize the managing member to consent in writing to a transfer?
It's a red herring. Why are we even
Well,
talking?
I'm just asking, does it say that?
I don't study 9.1 other than to look at it.
But I'm trying to understand what you're referencing as prohibited.
I thought the title said.
No member shall at any time during the existence of this agreement, directly or indirectly, voluntarily and involuntarily, including by operation of law, sell, sign, transfer, mortgage, encumber, pledge, or otherwise deal with or dispose of, transfer to any person, all or any part of the unit members in the company now owned or hereafter acquired by such member, without first obtaining the written consent of the manager, or following the procedures set forth in this Article 9. Notwithstanding the foregoing, only a qualified person may be a member and own units of the company. Any purported transfer in violation of foregoing shall be null and void and of no proportionate effect. In the 9.3.1, it says those transfers are accepted from 9.3.1. Is that correct? Didn't that say that in
That's the
9.3.1?
question, because I think we're in agreement that we're is that the only provision in this operating agreement that talks about the board's be ordering the transfer?
Provided, however, that any transfer permitted under 9.1 of this agreement shall not be deemed an offer to sell under this section 9.3.
So 9.3.1. Notwithstanding anything in this agreement to the contrary, a member shall be deemed to have made an offer to sell, and a company that or a non-selling family member shall have the right to purchase all of the members' units upon the occurrence of the following events. A court order, the attempt by a member to transfer any units pursuant to a court order property settlement entered into connection with marriage. So what that means, plain and simple, is when a divorce court tells a member you have to transfer your shares to the soon-to-be, divorced spouse, knowing that the corporation and offering some protection to the corporation member that they may not want to be in business with the divorced spouse, precisely what happened here. The whole point of that provision, Judge Rondelli understood it. Mr. Lundy, in his own divorce lawyer on the record, when asked, when the court said this transfer, will that then trigger John's right to transfer the shares to the corporation? Yes, he said, correct. Muni filed a brief in this court which he challenged the attorney's fee order, and he even said that courts have said it can be an abuse of discretion to require two spouses to remain in business together creates an intolerable situation, and that is in the record. So the whole point of that provision is to avoid including today, and that is he gets to remain in business with John and Charles Ohoka and be part of PCP in violation of this provision of the operating agreement. If we take this argument to its conclusion, and which is, in my respect and logical, combining this provision out of the
Which provision?
agreement.
That-
If developers,
By the way, I understand the concepts that you're elucidating here. And but we have in my opinion, a problem here. And I understand your answer is that it's an immediate buyback, but I have to read the agreement here. And not to mention that, I have to read your arguments and all the arguments made. And there's some confusion in the arguments made at the trial court and an appeal about who is the transferor and who's the transferee. In your briefs, you talk about Uni being the transferor. No, you do in your briefs.
I said that you're.
So the point is there's some confusion. So you can clear it up, and if I'm correct in explaining your briefs, I stand corrected. They stand for themselves. But okay. So again, so my point is, walk me through the immediate buyback concept in the language that I have to construe, that we have to construe in determining whether the trial court misconstrued. And that is that you're saying what it sounds like it's saying in a dissolution proceeding, that in which the trial court, you want to talk about broad and general concepts, and I get it, about the purposes of what was entered into. And that was that we can't value these shares, it's too hard, so we're just going to give her the shares. And then, and then if your argument, which seems to have been shot down in the first appeal, that is that 9.3.1 triggered the DOTS, that would have meant she would never get the shares. She would never get the shares.
That's the intent of the decision. Keep in mind, and again, it's.
So wait a minute, let me walk you through. So a family law judge said, look, it's too difficult to value these shares, too fraught. She's just going to get the shares. And then, right. And then John stood by and said, yeah, okay, that's the way to do this. Okay. And he's the managing member, and he can authorize that type of transfer, and that brings it out of the end of the 9.3.1. But you're arguing, no, 9.3.1 applies, which again means a dissolution, a final dissolution of marriage that says she gets the shares also meant by operation of the agreement, she never gets the shares. Is that what you're saying?
She's the transferring of the shares, and then to avoid the situation that everybody knows, because that including the family law. What's frustrating about this argument today? The appellant led with race judicata collateral estoppel. This issue not only has never been decided by the divorce court, the contrary position and the divorce court did, in the amended final judgment and the final judgment, the court said, making any findings whatsoever regarding duties, obligations, to the no way. That's for another, we're not doing that. She goes in and says, you know, he transferred the shares to Charles, he should have transferred them to me. Okay, fine. So she went on that argument, which John did, the step one. Step one was the divorce decree. The divorce decree ordered the transfer, John, meaning that he was doing the right thing or the TS. And this court said no. So he went back and did it properly. Okay, fine, I'll transfer them for, that was step one. Because the way he did it would have been a violation of the divorce decree. If this court accepts meeting after argument,
Actually, he didn't go back and transfer. Didn't the court do that?
the court ordered the transfer,
Right,
and it were the
right.
transfer. But that then triggered, it's a two-step process.
Wait, let me characterize it. You're saying he did what it sounds like you're advocating the agreement, the operating agreement should facilitate, which is essentially a fictional or a transfer to the transferee that never happens, which is what it says, right? If DOTS is implemented, the attempted transfer remains inchoate, so to speak, and it never goes to the transferee. It goes to PCP. And you just said he tried to do that, and this court's okay. Go ahead. Right, but that sounds like you're saying that all along this is supposed to sidestep the divorce decree, which gives it the share.
That we were not involved, not going to weigh in or what happened. We don't say that in the apples.
So she's supposed to get the shares and not get the shares.
There's a trick. We're here on an issue of contract. If we go to argument,
Which contract? The operating agreement?
the operating.
Well, and if you watch the oral argument in the prior appeal, the very first words out of Mr. Haskell's lawyer's mouth was, "You're here about interpreting that."
And he lost.
Right.
So now we are here.
And his, not your argument, but his fallback argument is what?
This is a new case. This is a new civil case. The amended final judgment divorce decree, not.
This is what it sounds like to me. This is what it sounds like to me. Okay, he shows up at the last appeal, Judge Kelly's recounting what happened in an oral argument and says, this is the way the operating agreement should be construed. Actually, it's the way I would read it, which is if there's an attempted transfer, he's the transferee, it's ordered by in a dissolution act, transferor, thank you for correcting me, he's the transferor, and therefore the actual attempted transfer to his wife is never to take place because it is cut off by the right of first refusal written into the operation agreement. He loses. So now you're saying, well, we want to accomplish the same thing, but instead we want to accomplish the transfer. We want the transfer from the transferor to the transferee, and then we want to force the transferee. This gets to my initial argument I had with you, or my initial point I wanted to clear up. Now I want the transferee to be bound by a provision that only binds the transferor. So you lost your client, not you. Your client lost on the argument that the DOTS requires an immediate buyback. How about that?
In violation of the divorce.
Okay, and now you want to say that no, instead we'll construe the operating agreement to say the transferor is not deemed to have offered it to PCP. The transferee is now deemed to have offered it to PCP, and the PCP gets to buy it from the transferee. Tell me where that is supported in the operating agreement. No, tell me where that's supported, not what the purpose of it is, but the language that supports that the transferee of an attempted transfer, we let the transfer happen, we don't stop it, we let it happen, and then the transferee is deemed to have offered to sell to PCP. Now the PCP is the right of first refusal, not of the original transfer, but they just get to buy them after the fact.
And again, Your Honor, if the language is inarticulate, we know what this is intended to mean. I mean, again, we are here on an issue of contract construction. We cannot interpret contracts to produce absurd results. This is the governing document that was never resolved in the divorce decree. So the whole point of it, and the only way to read it, is persistent the poster child. And again, my frustration is we came into this case very late. I wasn't part of the appeal. I'm afraid this court well has been poisoned by something that happened that has nothing to do with the issue now before the court.
You know, I'm not unsympathetic to the position you're in. But
It's a current
But
condition.
one of my concerns, and I think this was argued in the last appeal, where the meaning of the operating agreement was at issue, is that the real problem was the final judgment ordering this immediate transfer and giving her ownership, and that was not challenged on appeal. So if I have to accept it, it was a final judgment that does X, Y, and Z, and it wasn't challenged, are we stuck with that?
No.
Okay.
I'm not sure. Because if John Haskell was saying under the agreement, she never should have gotten the shares.
That was in the enforcement order, and that was like a major bone of contention in the appeal of the enforcement order, is you didn't challenge this provision of the final judgment.
I don't know how else to say it.
Okay.
This is an issue of contract construction that has never been before the court. Look at the amendment.
Okay, but then just looking at as a matter of contract interpretation, as Judge Atkinson said, what supports that the transferee has an obligation pursuant to the DOTS procedure?
What's the alternative? She gets to keep the shares and remain in business with PCP and her husband, and then that whole provision has gone out the window. Judge Guadalupe was very fair to have, and it's on the transcript, and they tried to.
Or it's not. If we're just looking at the plain language of the operating agreement,
The divorce decree triggered this deemed offer to sell provision, PCP gets the purchase unit. Why? Because the point of the provision, and these are.
From whom they get to purchase under the contract, they get to purchase,
To the transfer.
no, from whom, under the contract, does PCP get to purchase the shares under the DOTS? From whom?
From Uni. Now they've been.
Why?
she's-
Where, who's unique? Point to the term in the, follow. Point to the term in 9.3.1, that is uni in this situation.
Who
Member?
else could it be? I mean, who else could it be?
She's not in there.
There's
It's
a
the
divorce
member
decree.
that attempted this. I understand your point, and just as Judge Kelly said, I understand the situation. What has transpired in the previous appeal, but the point is, uni is not in that provision. Respond to this conception
Okay.
of it. A member offered to sell. That's the transferor, right? That's John.
So,
Where is uni in 9.3.1?
in the divorce decree, the spoken language of it was speak this provision.
Okay, the divorce decrees that's in the operating agreement language, attempted by a member. Who's the member? John, right? So where is uni and where is in 9.3.1, where does a right arise in PCP to buy shares from the transfer unit? And where's
It's
she?
implicit. It's not to me, I have all respect, common sensible. Could this provision be interpreted? If this court is bound by the rules of contract construction, the court would rewrite this provision on the contract if that's Uni's argument. There's no other reason for this provision other than to avoid exactly what seems to be about to happen, and that is that Uni gets to stay in business with PCP and her husband or
Judge Kelly expressed understanding about the position that your client, your firm is in. Why don't you can express, if you want us to do something, you can suggest your sympathy to our position. Okay, I understand what you're saying about the purpose, right? So what do you want us to do, and what do you want us to write an opinion when there was already an appeal in which the argument was made that the immediate transfer should happen, immediate buyback should happen, and you want us to write an opinion? You know, we only have what's gone before us, just like you only have what's gone before you, right? So you want us to write an opinion saying that this provision requires that once an attempted transfer is no longer inchoate, but has actually been effectuated, that the transferee is required to sell the PCP. Tell me how we write that in.
But secondly, the trial would have, and
Yeah, because the trial court said it didn't matter what we did in the last appeal.
well, and so this is why it's different. And actually, I think the first appeal helps us on this. So John construed this to mean that before, basically, I can violate the divorce court, which clearly that provision isn't meant to enable someone to violate. That would be a contempt. He was instructed, well, I mean, anyway, I can read this, you can transfer these shares to Charles Ron. Well, he got slapped on the wrist by a divorce court and said, no, I told you to transfer them to you. Okay, fine. So he transferred them to you, that was step one. We see this provision as a two-step process. He tried to bypass step one. Step one is a divorce decree, and it's written right in the provision. There's a divorce decree ordering a transfer, otherwise this provision would be to begin with. Obviously, there has to be a transfer pursuant to the divorce decree. He tried to sidestep that.
Ms. Borland, I've given you extra time because we asked you a lot of questions, but I am gonna have to wrap up.
Okay, so I'll just finish with this. You asked how can you write an opinion because of the first bill, and I'm telling you, it's a two-step process. You have been talking about where we are now. They're okay, fine, we'll talk about the divorce decree and the shares. It's gonna be, as you already said, basically an inchoate transfer, because there's gonna be an immediate like that, and the trial court recognizes that. That's the point of the provision, is that one common sense way to construe that provision. And I never got a chance to say that this entire repeal is based on federal estoppel and res judicata, and I find it quite offensive that the appellant is taking positions in this case that are directly contradictory to her position in the trial court and the divorce court, that KCP should be required to purchase shares. So again, we'll have to support to the Congress.
Thank you. Ms. Norris, you had 5 minutes. I let Ms. Borland have a few extra minutes, so I'm gonna be too strict with you, but I think we understand everything.
I agree. Look, I did want to talk on this one, but we're talking about this option. But while I was talking, apparently, all these operating agreements, they all kind of people, this operating agreement is different. And it has the exception that the manager. And really, you actually have parties in this operating agreement. So she was not a stranger. I don't know why they wrote the operating agreement they did, the way they did, but they didn't write it like. For no other transfer.
A member, or is the member status here? Is he one simply by virtue of the agreement?
I think it's member, if you look at the definition, the word units, whatever. Would have to resolve that, she's certainly an owner of the units. I don't see anything that would require her as an owner to sell in the once you. That really is the problem with it, that you cannot read the DOTS consistent with the owning units. That is not that accountable. And so if you read it that way, then the court has violated the operating agreement or something. And then that way there is a case. This is not a good case. The facts in this case are exactly what they were. They're exactly what we were talking about. And I think it's telling that it's been admitted that this first attempt at the DOTS was an attempt to sidestep clear language of the mindset.
Let me ask this, well, what if we were wrong? We get things wrong. What if we were wrong? And what if the final dissolution was to be effectuated this way? There is the final dissolution constituted what is described in subsection E of 9.3.1, which is an attempt by a member, John, to transfer his shares. And that attempt, by operation of the agreement, is deemed to be an offer to sell the PCP. So why is that inconsistent with the final dissolution of marriage? In other words, an immediate buyback. And there's been reference by appellees that counsel for Uni at the time, there was discussions during the dissolution proceedings that acknowledge that, this essentially is going to be a situation in which the transfer never really actually takes place immediately. 9.3.1 kicks in. To leave aside the previous appeal and answer that question.
Okay, I'm going to try to break it down because I think the first question was, what if we were wrong?
Or why don't I say, what if that appeal never happened? Let's just go back in time. Why can't that be consistent with? Why can't that be consistent with the final dissolution of marriage?
That can't be consistent with the final judgment of dissolution of marriage because it said that he had to transfer a neighbor and owner. Okay, so if he said, if his position was, I cannot.
So you're saying, so in other words, you're saying that final dissolution of marriage overruled 9.31, or it was done pursuant to 9.1. Is there record evidence that suggests that the the dissolution court and the parties understood that this was happening under 9.1?
There's no citation to 9.1. There is a reference, and we talked about it in the brief, and that's where, and I forget which said the divorce court of jurisdiction over John, in order to him to do that, he said he wanted to the divorce court could direct John to do anything which he was authorized to do under the operating agreement. There's no specific reference. But then the court accepted vice testimony, the vice expert testimony. There's no real value to be distributed in fine.
If I go back and look at really closely at the divorce proceedings, what impression would I come away with? That it was understood that this 9.3.1 would automatically be triggered upon
I don't know that you can come to a fair conclusion. Like I said, Mr. Lundy said, and the excerpts that are on the record and they're full transcript on there. But the excerpts that are in the record, there's some discussion about.
I don't want to go outside the record, obviously, but I'm saying, you know, what.
And then there's a discussion about, well, you can prefer to do anything that the operating agreement do. So I don't think you come away with a definite, I know what the judge is doing, and this is what she intended.
So
So then you're stuck with the language of the language. He must transfer.
and make her an owner, and so you're saying that's inconsistent.
Stay silent, because that would get their time to right. And I think that's a problem here. The first thing he did, try to sidestep it. They let the DOT it, and that got shut down. And that was resolved. So I would ask the court to reverse the order and appeal and direct it to the media.
Right, final case this morning is Pond versus Lewis.